In this video I'm going to take a look at making a plea in mitigation. So what is a plea in mitigation, I hear you ask? Basically, if you are pleading guilty to an offence in the district court, for example, or indeed any court, then you are obviously going to be sentenced. This is a criminal offence, obviously. So the likes of theft or drink driving or careless driving or dangerous driving or any road traffic offence or indeed any other criminal offence. So if you plead guilty, then you're going to throw yourself at the mercy of the court and get as much or look for as much leniency as you can possibly get. Likewise, if you do not plead guilty but you fight the case, you go all the way to a hearing and you lose the case and you're convicted, well, in those circumstances you're going to want to make a plea in mitigation then too, because you want to soften as best you can the harshness of whatever penalty is going to be imposed. So let's take a look. As I say, if you're convicted of the offence, so you plead guilty or you fight the case and lose, then you're going to need to make a plea in mitigation of sentence. This should be done by your solicitor or your barrister, depending on your circumstances. The purpose is to ensure as much leniency from the court as possible. There are 18 things that I would kind of look at when I'm doing it for a client of mine. First thing would be the family situation, the background, the history of my client. Judges like to know, well, some judges like to know, what is the family background and what are the circumstances that led to this particular person being before the court on this particular day or indeed other days for various offences. So that's one thing. Second thing is the work history and the current circumstances of the person who has pleaded guilty or been found guilty rather. So, have they a professional career? What is their background? What is their work history? Have they been unemployed for quite some time? Have they ever worked? Have they had good jobs? And have they a responsible job or career? The third thing that we'd look at is the education. What is the educational circumstances of the person that's before the court? Have they left school early? Do they have third level education? Are they professionals or whatever? The fourth thing that I'd look at then and put before the judge perhaps would be the age of the person. So the level of maturity or experience obviously will be a factor. Let's face it, when I was 21 or 22, I was a good bit less mature than I am now. So an older person then as well. I mean, if somebody is, say, over 65 or over 70 or over 80, well then clearly the effect of a custodial sentence on them is going to be fairly significant. So that will be taken into account by the court. Fifth thing that you'll be looking at would be the effect of jail on the particular person. So, on the family circumstances. Is the person who's convicted the sole breadwinner in the household? Is there young children in the household? So even though the judge may want to punish the person who has pleaded guilty or been found guilty, who has been convicted of the offence, the effect on the children of that person may be something that the judge will want to avoid if he can help it. So going to jail may not be the best option in that regard if he is the sole breadwinner. Number 6 is the health of the convicted person. This is a factor, or may be a factor, in whatever sentence is going to be handed out. Number 7 is addictions. Do they have difficulties, addictions to drugs or drink or anything else, gambling, etc., which might explain to a certain extent the fact that they're before the court for various offences. What are the efforts at rehabilitation that the person has made? Has property or money been recovered? And have they made genuine efforts to deal with their difficulties, their personal problems, be it gambling or be it alcoholism or be it whatever? Remorse then is number 9. Have they shown remorse? You'd be looking to the guard to confirm that they were co-operative and remorseful, etc., etc. But it depends obviously on the circumstances. You can't mislead the court either or tell barefaced lies. Has the person made an apology, and have they made any restitution? An apology would be something that would be very important in a situation where your client or my client might be convicted of assault, for example. Have they made restitution? So have they made compensation if it was physical or material damage that was carried out, or perhaps money or something that was taken? Well then, have they restored that money? the apology, is there an apology and is it genuine? Obviously it's good to be able to tell a judge that your client is apologetic and recognises the silliness, the foolishness and wrong-headed behaviour that they've been engaged in. Number 11, have they been cooperative with the Gardaí? If you plead guilty at an early stage, you're going to have no difficulty, well, little difficulty, getting the Gardaí to accept and perhaps give evidence, if necessary, that your client has been cooperative with them from the word go. However, if your client insists on fighting the case the whole way to the end, goes to a hearing, gets a buttload of witnesses in to give evidence and puts the state or the prosecution to a significant degree of cost and time, well then they're hardly going to agree that he was cooperative or she was cooperative. So that's something that you need to consider. The 12th thing that you'll be looking at would be, is the plea, if it's a guilty plea, at an early stage? Or is it, as I say, a protracted prosecution, and has there been delays and ultimately a hearing involving witnesses and so on? The next thing that I'll be looking at would be previous convictions. Has the client previous convictions? What is the number? For what? How long ago? Clearly a conviction only last month or 6 months ago is of far more significance to a judge than a conviction maybe 10-15 years ago, where somebody might have gone ape on a weekend bender or binge or stag party perhaps in Carrick-on-Shannon or Castlebar or Westport or somewhere, and they got done for public order offences. So the nature of the convictions, how many and how long ago, would be factors that a judge will take into account. The circumstances of previous convictions is important. As I say, is there any mitigating circumstances for those convictions? Was it a question of maturity or immaturity? Perhaps, as I say, stag weekend, public order offence, urinating in the street when you're 21 or 22 years of age. Was there peer pressure, or perhaps was the person in desperate financial straits? In other words, were they compelled, for example, or felt compelled or under duress to maybe take money from the workplace, where they were facing perhaps eviction from a house or foreclosure on a mortgage or something like that. Next thing I'll be looking at would be any hardship pending. Is there any pending charge or any loss of job or loss of marriage or any other hardship pending or likely to be the outcome as a result of the conviction or the pending charge? So clearly losing your job, if you've a good job, or even if you've a not so good job, losing your job is a very, very significant penalty. And that's obviously going to be a side consequence or byproduct of whatever penalty the court might hand down. So that's something that the court will have to consider. Compensation to an injured party is another one, particularly with an assault case. So, was compensation offered and was it actually forked out? Whether the person is perhaps a non-national, have they any difficulties with language? Would they have any particular difficulties if they were sent to prison because of their lack of communication skills or the fact that they're not Irish? That might be a factor as well in a judge's consideration in relation to the sentence to be handed down. And finally, was the person under any duress or provocation which led to the commission of the offence? Obviously duress or provocation can only go so far, but certainly, there can be factors, and the judge should be made aware of any provocation or duress that was present which might have given rise to the conduct which led to the conviction. My name is Terry Gorry. If you liked the video, you might give it the old thumbs up in my YouTube channel or on Facebook or wherever you come across it, and you might let me know as well in the comments what type of video you'd like me to see me making. I have a lot of videos on YouTube about all aspects of Irish law. Thanks for watching.